Good afternoon, gentlemen.
Yes, sir.
Are we going to have 2 people or 2 people?
Victor should be here, so.
We'll stand by for a minute.
Yeah,
How are you?
good. How are you?
Okay. Had a dramatic, stress-filled 2.5 hour initial interview this afternoon. Ready to fall over. Very hysterical client.
Yay.
She wasn't sure she should spend $5,000 to protect the $1 million that she has that her husband might try to get away from her. I thought she should spend it.
I do as well.
How are you?
Pretty good. How are you, Professor Mack?
Okay.
How's life treating you?
Fair.
Okay.
Are we starting on 477?
Yes, sir.
That's what I read.
To the end of the chapter, and there's one case.
We'll have the 3 of you brief it verbally at the same time.
At the same time.
Sounds good.
I mean, it'd be pretty easy.
Well, we'll just talk louder. We'll just like.
See who can get the briefest.
There was one thing that I read here, and I sent myself an email to copy that page, because it could be really important, and I didn't do it. And I need to leave the book here, so remind me to do that, please.
Okay.
Hey, this, when I read Duffy, I thought that lottery case, lawsuit, I thought it was more money than that, and I thought it was out of San Francisco. But this is Southern California, I think, and it wasn't that much money.
Yeah, no, it was only $1 million. Split between a couple people.
But I thought it was like one lady won all by herself.
Oh. It
Oh, no, it was 6
million.
million, and she won $1 million.
Right. It's still like.
How are you?
Excellent, thank you again for that, for your donation.
You're welcome.
But you wouldn't even be joining us.
I will. That's okay. That's okay.
Did you guys get the sign-in sheet?
Negative.
Oh, okay. I can't find that in the program. We'll go make one up for you.
Okay.
I have 2 cases right now involving the request to set aside the divorce judgment. One of them, I'm the moving party, and a very uphill battle, in my opinion. In one of them, I'm a defending party, wanting that the judgment stay in place. And I think I've got that nailed. I think they blew a statute, period. And there's certain circumstances in which the statute is set aside as a year, others that are 3, seems 5 years old.
Oh.
Could be simple. Hi, how are you?
You're doing a version.
Fraud is
Now, is it based on, well, it seems like you guys want to, usually there's like a reason for they want to, dismiss the judgment or set aside?
set it aside.
And is there like a knew or should have known, like 3 years from when you knew or should have known of
Yes.
the
I think
reason
that's
set aside?
exactly, if you're basing your request on fraud, I think it is that. Thank you very much. Mine is not fraud. Mine is unacceptable. Um, um, Duress. And I think that we have a hard time with it. After an agreement was written down, the parties were dired by the court. You understand the agreement? Yes. Understand that? I just went through the whole thing very carefully. I will tell you that the judge was Mickey Reed. My client was the respondent. Trial was set for 14 days, 13 days. At the end of 7 or 8, plaintiff rested. My lady had not begun her case.
Oh.
And
Begun to prepare or begun like
to do her case in chief.
Okay.
And the judge said, after she heard the terms of the settlement, I said to my client, I wasn't the lawyer there, I can tell you that what they're offering is better than you're likely to get from me.
No.
She had no business making that statement.
Mm-mm.
It pushed our client into agreeing to it. I mean, the judge should never make a comment about the analysis of the case, particularly when only one side has been heard.
Yeah.
So we're going after the judge. It's Mickey, an old friend.
She's a nice lady. But mistakes are
Very nice lady.
Mistakes shouldn't hurt your client.
Well, I mean, she saw shit. If I don't sign up, I'm going to do worse. I need a pen, somebody.
Here you go.
I've never had a pen in my possession before. So. This lady's in the Philippines. It's very hard for us to talk. It's 15 hours later there.
There's quite a time difference between here and the Philippines.
15, we FaceTimes when we see each other. And we do it at 4:30. I'm sorry, that's okay.
That's all good.
At 7:30 in the morning for her the next day. So I asked her what happened overnight because she's already had it overnight and I didn't.
And I did that with my cousin in Germany. I was like, so what happened today? And they're like, I don't know much.
I want to know what the Asian markets did. Can you tell me about that? 477 begins section 4 of chapter 6. And one of the things that jumped out at me when they talk about fiduciary obligations and duty to disclose, they're just so unrealistic in a real world. Even if you're not trying to deceive anybody, I mean, when was the last, anybody here married?
No.
Nobody? Shit. You don't understand what's going on with community property. I've been married many times.
This class is making me not want to marry ever.
Sheila begins the class by saying, when you get married, you have agreed to obey 15,000 rules, and you don't want to be subject to them, don't ever get married.
That sounds like Sheila.
I have a very checkered past. I was married for 30 years, and then 5, and then 5. And I'm on my 4th marriage, never thinking I would ever have more than one.
Just say, how do you do that working in family law? I feel like that would turn you off from marriage completely and totally.
I don't like dating.
No.
So anyway, now I've been married for about 8 years. We got past the 5. But I warned her when I got to 5 that it's been the end of my preceding 2 marriages. When do fiduciary duties spring into existence?
At marriage.
At marriage,
And do they ever end?
at separation, right? Ken?
They end at
Absolutely not.
No, when.
partially at
when-
separation and
Dispose.
then partially at an order for dissolution.
Yeah.
No fiduciary duties
So you
end at separation.
Um,
The characterization of property acquired thereafter is different. What you acquire after that is separate property, not community property. But your duties to each other of full faith and fidelity and disclosure of assets remains until a judgment is entered. A judgment by way of settlement or a judgment by way of trial, but not until it is absolutely over do fiduciary duties end. So don't think you're free to do what you want because you get separated. I hope none of you ever do that, but you might. And hiding assets, spending community property money, spending it on a girlfriend is not a good idea.
Does that include, is it spousal immunity?
Does spousal immunity end? Spousal immunity would end at the termination of the status of the marriage when you become single. And that might not be at the end of the case. Because if you go 6 months and a day since the respondent was served with the divorce petition and make a request to the court to bifurcate status, the court will grant that. And you can take status, which means to put on the prima facie evidence as to why you want a divorce and are entitled to a divorce, and you can be declared single. So now you're single. So I think spousal immunity has gone away because you don't have a spouse anymore, but fiduciary duties have not ended. The case has not ended. All that's happened is you've gotten the status of being married terminated. Not much reason to bother with that. It costs some money. Some people want to. I may have told you before, I don't remember anything in my life anymore. I had a very nice gentleman, maybe 35 years old, come in. I mean, he was a client. And the case had been going on for a while. And he wanted to know if there was any way to get the divorce now, even if we couldn't conclude the case. Yes, you do a motion for bifurcation, it'll be granted. As long as 6 months and a day have gone by since you were served with the petition, you can terminate your marital status. It costs some money, I don't know why you would. He said, well, I've been dating this girl for 7 months. I really like her and we've become very close. And I want to have sex with her. But I can't and I won't so long as I'm married. So if you can get the marriage ended for me, then I can do what I want to do. And I thought, well, that was very 1950-ish, which I remember, you guys don't. But I thought that was pretty cool. And so we got the, you ran out of the courthouse the day we got the divorce. No, you What does it mean to have a fiduciary duty to your spouse? What does it really mean? Tell me.
It means that you have a special, based on the special relationship, you have certain obligations of a special nature with that person. And there are various, once we go through this chapter, that hold the person to, honesty and regarding your contracts with others and your finances and things like that. That you have an obligation to be forthcoming with that individual at certain points in the process.
We know you have to do that kind of disclosure when you get a divorce, but do you have to constantly update your spouse about your income and your expenses, and you just have to, you want a daily report at 5 p.m. if you get home from work? I earned $350 today, dear, and I spent $184. Next.
I think it's when you are doing something significant with the money that the duty becomes necessary to, like for example, if you're going to take a huge amount of community assets and apply them to something without permission or knowledge, that would be a time that you should, that the duty would pop up. So I think that in certain transactions, certain occurrences, the duty kind of rears its head.
The more significant the transaction, the keener the fiduciary duty, perhaps.
Sure. Yeah.
I don't think I've ever read that, but I think that's true. One of the things that I found interesting was how you can actually file suit for an accounting not connected with a divorce. Can you imagine suing your spouse, saying, I want the court to order you to give me an account? Isn't that marriage?
Part of the divorce.
Isn't the marriage over?
Yeah.
It means the next one's gonna get a divorce.
What would be an example of an impairment claim? What might one spouse do that would give rise to a proper impairment claim? And I don't think that's in your book.
That'd be like an investment, wouldn't it?
They invested their entire retirement into something that wasn't sound.
Yeah, because they have like
Very, very well could be.
the old Duffy case, which is no longer good law, but I mean, they basically, if you're doing something, you have a duty to, you're doing something that's injuring the community assets, you have a duty to disclose that impairment.
One of the things that happens in cases, that's a correct answer. One of the things that happens in cases is not infrequently, you could have one spouse on title to a property alone. Actually, it happens fairly regularly because if you had the other spouse on the loan, let's say the female, and her credit record was shit, that could impair the ability to get the loan. So sometimes the husband is the only borrower and title is taken in his name alone, but the down payment came from community property money. The payments were made with community property income. It is community property. But he has the complete ability to go take out a second. You got a $400,000 house with a $250,000 mortgage and a $150,000 worth of equity. He could go out and borrow $50,000 without her knowledge at all. Not permitted. Transaction would just be set aside. If you bought a condo with it, probably order him to sell it. Certainly, if there was other money, order him to reimburse her for that. Then we'll talk about dividing up community property. And I probably said it last time, as I say it all the time to clients, disclosure is protection. If you're not sure whether you should disclose something or not, keep in mind your duty of confidentiality. And if you're not sure, just disclose it. I think I did tell you this story about a client I've got who has a girlfriend, and he spent some money on her. And his wife doesn't know about the girlfriend or the spending of the money. And we get what's called form interrogatories, which are questions that are standard questions. They're form interrogatories in connection with a divorce. And one of the questions toward the end of the thing is, what money have you spent on any third persons that your wife is not acquainted with? How easy would it be to say none?
Very easy.
By definition, they never know. My client didn't want to disclose it. I said, we are. And they wanted the name and address of who got the money or who it was spent for. Disclosed it all. Does it hurt our case? Yes. Did we do what we had to do? Yes. Was the client happy? No. Was he willing to do what he was obligated to do based on my advice? Yes. What would I have done if he had told me about this conduct and expense and refused to let me put it on the schedule of, in response to that interrogatory?
Give it to the client. Yeah, you'd have to end the relationship at that point.
I tell him, no one will ever know about this. I'm not going to represent you any further. I'm not going to participate in the fraud. And that's happened in my career a couple of times. Are you crazy? Nobody will ever find out. I said, well, you know, that's true about all kinds of misconduct. Probably steal a lot of candy bars without being caught. It doesn't mean it's acceptable. Anyway, follow the rules. Disclosure is protection. When you file a divorce, there's a summons, like there is in every case, that you serve along with the divorce petition or the civil complaint or the probate petition. But there's a summons as part of it. And in family law, there are ATROs, automatic temporary restraining orders, that go into effect. They're imposed on the petitioner the day the case is filed. They're imposed on the respondent the day he or she is served. Prior to that, they didn't know. And one of them is to not impair the value of any asset in the case. Even if you think and know that it is your separate property, you can't impair the value of that. It may be needed down the road to equalize community property. Ran into a problem today. Not many spouses want to leave their estate to the spouse they're divorcing. And you can change your will or your trust anytime you want, up until the time you file the divorce. Once you do that, you can't change your will and you can't change the trust until the case is over. And you can't change the beneficiary of a life insurance policy until the case is over. So you got $1 million policy. Your wife has been sleeping with the milkman and the mailman and the gardener, and you want to divorce her, and you don't care for her at all, and you certainly want the life insurance to be left to your 2 children, not her. You can change the beneficiary today, but not if we file tomorrow. After that, you can't. So what I've been doing, not necessarily as carefully as I should have during my career, is I am getting clients to an estate lawyer before we file a petition for divorce. Go see him or her, change your will as you wish, change your trust as you wish, get it signed, come tell me it's done, then we're going to file the divorce.
So that's not an impairment, because, I mean, I guess if it's their.
You're not touching anything.
Right.
You're just making your testamentary wishes known.
Well, you said trust, so you're saying that just testamentary trust, like you're not messing with the inter vivos trust at all.
You can do that.
You can do that. Okay.
But you can't take away from her what is hers.
Right.
If there's $1 million in an inter vivos trust, and she's entitled, community property, and she's entitled to half of it, and she's entitled to the other half because that's what the trust says. Like, she gets everything until she dies, and then there's contingent beneficiaries.
Right.
So,
You can't touch her half, but you can change your half from her to other people.
right, so that's basically what I'm thinking. Like, let's say that you have Intergo's trust that, like, you know, it's my real trust, and I have assets in it before I get married, and like they're my separate assets and they're mine, and she's the beneficiary of this trust if I die.
The whole thing.
And what I want to do is say my kid is, and then go get divorced, right?
Yes,
That would be okay.
yes.
Okay.
I thought you couldn't do testamentary changes of community property without written spousal consent.
I think you can, so long as none of the changes change her share.
Oh, change her share. So you can
You're
change
entitled to half.
your half.
Correct, correct.
Okay.
What you can't do is change it so that it all goes to your children.
Okay.
A lot of second and third and fourth marriages, and they want everything to go to their children from 20 years ago. Maybe not, but the point is you have the right to do it. And I think you can change a trust that is completely community property before you file the divorce, so long as you don't change the beneficiary of the trust to any extent more than half.
Right. Okay. Okay. But what is yours, you can give to someone else.
Correct. And I tell you, along a similar line, there are people who are, as far as I'm concerned, misconduct practitioners, either on their own initiative or because the client says, I'm afraid she's going to take everything. We got $150,000 in the bank and I'm afraid she's going to take everything. So they tell them, you go take it.
Oh.
Put it somewhere else in your name, we'll disclose it. But she won't be able to take it away and hide it. I never recommend that they take $150,000. I have no hesitancy to say, take 75, secure it someplace else. We don't have to tell them right now, and advise your wife that that account now has 75 and you make no claim to it. Who wants to tell me about Rossi?
I mean, I can do it. Basically, this lady entered a lottery pool and ultimately pulled out of the lottery pool. But the pool ended up winning, and one of the parties told her, as a gift, we're going to give you the share, supposedly.
Have you taken taxation? Excuse me.
Oh, we don't get a separate class on taxation. We do get wills and trusts, though it's some of the tax issues pop up, but
That woman gave her that interest in the pot. That was a gift. That's a gift tax situation. We'll talk about, well, we won't talk about that.
I think as much as we know is you can give up to 11 million in gift money, right?
No,
You're talking about estate taxes.
Oh.
Yes, gift is 14 or 4,000 or something like that.
Not the first time.
14,000.
Per donee per year.
Yeah.
Oh,
but
okay.
it's 15. I'm 99% sure.
I thought there was a 4 in there.
In that general area.
Yeah, it's 15.
In that general, yeah.
Because I got, never mind.
You got
15.
You want to get rid of your kids, you and your wife can each give 14 to each child each year. So each child can get 28.
Right. Oh, that's cool.
Wife can do it, husband can do it. Go ahead, sir, I'm sorry.
No, so the jackpot in total was just shy of 7 million. Denise ended up getting $1,336,000, and it was to be paid in 20 equal payments. She went to the lotto office and said, I'm thinking about divorcing my husband and I don't want him to get any of this, so what do I do? And the lotto commission told her, file for separation before you claim the jackpot.
Co-conspirators.
So that's what she did.
Legal advice too.
Yeah. So she filed for dissolution from her husband, and told the lottery to send everything to her mother's address because she didn't want her husband to find anything out.
Really would have been an easy case to decide, I think.
Yeah. So what had happened was she ended up getting a lawyer for the dissolution, though he didn't have a lawyer, so her lawyer drew everything up. Within the dissolution agreement, the settlement agreement, they had certain paragraphs in there about fairness and candor, and everything had been disclosed, and settlement agreement was ultimately signed and done, and there was a dissolution entered in April of 1997. Ultimately, in 1999, a letter was sent to the husband's house asking if the wife was interested in a lump sum buyout of her lottery winnings and no longer getting the annuity payments. Husband calls her up and says, "What the hell?"
At least.
And so she does, or her attorney confirms that she won the lottery and that she's unwilling to give anything of it.
Please note.
So
They had filled out a schedule of assets and debts.
yeah, they filled everything out and she never disclosed it ever. She admittedly hid it.
And she could have filled it out as separate property.
Yeah, she could have filled it out as separate property, but she didn't. She just left it all off. So he ends up getting an attorney. The attorney brings an action to cancel out the dissolution based on fraud, and a breach of fiduciary duty and a failure to disclose. Ultimately, the trial court found that Denise intentionally failed to disclose the lottery winnings and that they didn't believe anything that she said about the gift, even though she had an affidavit from the lady saying that it was a gift. And she testified that she was afraid to disclose it because he had a gambling problem, he was vicious and beat her, and a whole slew of things. Ultimately, the trial court said that because she intentionally concealed the lottery winnings, that under sections 3294 and 1101, that Thomas would get 100% of the lottery winnings. So she appealed. The Court of Appeal basically said, you're screwed. We believe the record in that, and the trial court in that you intentionally and voluntarily withheld this information, and because of that, you fall under section 1101, and as a penalty, the trial court would not abuse its discretion in giving away all of it. So, awarding all of it. So Denise was screwed.
She wasn't screwed. She got exactly what she was entitled to.
Yes.
Well, but she probably, if she could have proved her gift from the beginning, she could have just disclosed it. She could have said, yes, I am getting this shipped to my mom's house. It is a gift by, blah, blah, blah. It would have been hard to prove the gift. I think the gift is a little fishy.
Well, she would have at least kept half, though, if she disclosed it.
No, but if it was community property, if it was a lottery winning, what she would have gotten half. If it was a gift from the group, I think it'd
Be separate property because gifts are separate property.
So, yeah, I mean, that it would have been half or all of it to her, but the fact that she didn't even disclose
the
it
disclosure issue.
is the issue here. And she breached her fiduciary duty and as a punishment.
If you look toward the bottom of page 490, you'll see a paragraph that says Denise argued that the trial court order had to be reversed because Thomas's attorneys received half of the lottery proceeds. What the fuck is that?
That was their contingent agreement.
You see some very important words after that, where it says without citation of authority. Now, it doesn't mean you need to brief everything you take into a courtroom. You don't. They don't want you to in family law. There's too many things that are well known and repetitive. But I tell you, and Mickey was very good about this, to my embarrassment on a couple of occasions, when you present an argument, it's a little novel. a little bit, not exactly what you're normally dealing with. What is your authority for that, counsel? You better have a case in mind, or a statute in mind, or dicta from someplace in mind. Can't just be creative and argue that that's a rule. You'll be called on it.
Equity only goes so far.
Yes. So the case is over, wife loses in the trial court, that loss is affirmed on appeal. I have wondered, and I'm not sure I have the answer now, but we can look it up. When it says respondent is to have his costs on appeal, what are the costs to which they're referring?
Right, so it's not attorney's fees, it's, and it's only reasonable cost. Basically, you get like this, like your mailing stuff, you don't get that much. I think you get your filing fees, things like that, but costs, there's a schedule of costs.
You get your filing fees, you get, because we just did an appeal and got costs.
Did you?
And it's, so you get
I had to do
your
it
filing
cost
fees,
once.
you get basically all the costs that you had to pay for the different copies that you have to send to the appellate court, because you have to send like 7 paper copies of one thing, 9 paper copies of another thing.
We
And
just finished doing that.
yeah, so you get like all that back and how much ever it costs you to do that. But they have prescribed amounts that you can charge for each thing.
What about the family law case in which there's a code that provides for attorney's fees?
When I was
Okay.
put together.
Well, then that says otherwise provided by law, but that's not gonna be a cost. You're gonna have to bring that as a separate issue. Costs and fees are 2 different things. Which should,
Oh, here is that reference in the notes on 491, item 2, that husband's name alone was on the title because his credit score was better. And, you know, if you got one decent and one bad and you have both applied, your loan application might be denied.
what was the under intent rule under businesses?
Under businesses?
Right, so,
The party is responsible who the lender was looking to for the repayment of the loan.
that's it. Is it the same way in community property?
Yes.
Well, we know we learned the lender intent rule in community property.
Did we?
Yeah.
Okay.
Yeah, no, it's that if the lender intends to rely only on separate property, then the loan is separate property. But if the lender looked to the community to determine whether they were going to loan the proceeds, then the loan itself is community.
Community
like in regards to businesses.
Yeah, sorry.
That was like chapter 3 or something like that,
Yeah.
or 2.
Okay, thank you for the refresh.
I've got a case now in which the husband took a lot of money out of a community property bank account, withdrew it and transferred it into 2 bank accounts in his name alone. She didn't know anything about it. And we discovered it in discovery. We're still fighting to get the documents that we're entitled to, but we got a bunch of documents that showed wire transfers to an account that my client didn't know anything about. It had an account number. So we sent a supplementary document demand saying, we want to see all the documents regarding account number such and such. What were the transfers? 20,000, 50,000, 40,000. Big numbers. There was something in here that I read last night, preparing for tonight. Here it is, I found it. I'm looking on page 495, item 7.
7, yeah.
The concealment of community property assets may result in criminal charges. And they don't cite a case, they cite an article. I want to go read the article. So I want
Or the gentleman took the money, took it to Miss Southern, and then he took it up overseas.
Yeah.
And you invited him.
Yeah.
But for transmitting stolen assets across state lines.
That made it federal. If you're gonna sleep with a minor, don't take her across the state line. Stay right here. Crossing state lines creates a federal jurisdiction.
But even transmitting, oh no, okay. So then what would be, I guess just steal, I guess you, like a misappropriation
What?
or like an embezzlement?
Like why this is illegal?
Well, I'm asking how it would be a crime under, like regular, not the federal, like transmitting stolen property or state lines, but how it would be a crime under, just a regular, penal code.
Because it's still theft.
So it's an
It's
embezzlement?
like, yeah, well, no, it's larceny.
Well, what kind of larceny?
Grand larceny if you're stealing 1 point something million.
I don't think it is though. So I think it's entrusted to you. Like it's under you. You have control over it.
You have control over house.
Investment.
It's
I
community.
think it's embezzlement, right? Just because you're misappropriating the property of another.
I tried to look up the article, I can't find it.
Oh.
Well, this kid, I mean, it seems like the guy knows it's not his, which is why he's going through such effort.
Well, it's similar with embezzlement. If you take like $1 out of a register that you're working at, that's embezzlement. It's not larceny, because you have control.
What is larceny?
Larceny,
Contrast to embezzlement. I mean, I know what embezzlement is, but
right?
so
So
larceny theft under any circumstances, and it's just broader.
Embezzlement is a larceny.
Yes, I think it's a subset of larceny.
yes, yeah,
You're just entrusted to the property, is the difference.
right. Yes, the property it has been entrusted to you. That's the difference.
But has it been entrusted to you?
I'll look up my old notes from 1L. I don't recall.
Well, no, I know that's what that is what embezzlement is. But I'm just saying, like, only half of the community property has been entrusted to you, not the other half.
So then half you stole and half you embezzled. No. You only embezzled the half because your half you could do whatever you want.
Exactly.
So you embezzled half.
You can't steal from yourself. Is that what you're saying?
Correct. That's my understanding.
Really, one of the elements is property of another. Right?
Yeah.
Anyway, I found it interesting at item 7 because we really now have this guy substantially nailed. But you know, and we can show they took money out of a joint account and put it into a new account that we didn't know anything about. It was in his name alone. And it says here in this paragraph, this case marks the first time in California that a husband has been charged criminally with stealing from his wife. And I tell you, with that in mind, you're never going to get law enforcement to give a shit. That's a civil matter.
Yeah.
That's a family law matter. We're not even writing up a report to give to the DA. But I assure you, my client would love to, and we've got the evidence.
We have those issues a lot when, so we do businesses and real property. When one partner wants to take up there's basically a divorce of partners, and one partner wants to start taking all the assets out of the building, and they'll call the cops, and the cops will just say civil matter and walk away. Even though it's no, that's my stuff that he's taking it. Right now he's stealing my stuff. And it's civil matter.
Very common. Also, depending on what department you're dealing with, domestic violence restraining orders will be enforced or not.
Okay.
I mean, there's a lot of cops that just hate women because they've been abused by women in some way, they think, or they have been. And so they've got a woman with a restraining order, and it's being violated. And they say, we're not going to arrest him. Get out of here, mister. We're not going to arrest him. What you're going to do, file for contempt? I have so many cases in which I'd like to file for contempt. I spend a lot of money, a lot of time. You get a court-appointed lawyer because it has criminal implications. It's not worth it.
I looked up California lawyer. It only has archives back to 2010. So I can't find that article.
It only goes back to 2010 in the computer.
Yes.
I'll bet if you got in touch with a California lawyer.
Yes, I'm sure you could get the 1995 article.
Email them. Come on, man.
Give me their email address. Request it.
Step up, Vincent.
I'll tell you about a case in connection with Section 5 that was an eye-opener for me. We had a guy, a husband, who owed a lot of money in support, spousal support. He got married. He had separate property. They had community property. She had separate property. And the ex-wife was going after the new wife's separate property. I argued you cannot do that. That is not an asset subject to execution.
I think the best way to do it is to
That's what I'm doing right now.
probably there's a way to send inquiries related to the website for specific questions.
You guys are so good. You really are.
I can send you this page.
I'm just gonna ask them for it right now, and then if they send it to me, I'll forward it to you because I have your email address.
He's already gonna talk to me.
Let me know when we get out of law school and pass the board.
Okay.
Anyway, the court ordered that the new wife's separate property was liable to pay her husband's ex-wife's spousal support arrearages. And if you read Section 5 about 10 times, I think that's true, but it's just astonishing.
Wait, say that again. So second spouse's separate property can pay
Can be
the spouse's debt
ex-wife
to another.
to a former wife, her spousal support that he owes. Now, his separate property, sure. Community property, yes, because he has an undivided 1/2 interest in it. But her separate property, it's just out of the question.
Okay, so you can't go after anything that's hers. Like you can only get, you can only get his separate property and half of the community, and that's it.
No, I lost. The judge said it is proper for you to seize the new wife's separate property.
New wife's separate property.
And then he said, I'll tell you what you need to do. This is also something we don't do from the bench. I'll tell you what you need to do to avoid that loss. Divorce him. Have that confirmed as your separate property, and you won't be his spouse, and his former spouse won't be able to touch your separate property when you're not his wife any longer. She filed for divorce the next day.
Sure, but I thought that the character of separate property is still separate property during the marriage.
It is. I've never quite found the rule that permitted the court to do that.
Okay, you just kind of.
She decided to just file for the divorce instead of appealing the ruling.
Okay. Yeah. This is quicker. That's sad.
Now today, talking to this lady who has just a long list of assets, and there's a bunch of them that the husband wants, and her position is take them, but her name is on the loan regarding it. So if he doesn't pay it, they may come take it away from him, but it's going to be her credit that's going to suffer. So he wants to take it tomorrow. I said, well, if he wants it, and that's okay with you, tell him to go get a loan and pay off yours first. So we'll see. They've got some equipment that's pretty expensive, like a tractor. I guess they're kind of like farmers. Now, if you can come up with a case in which there is a set aside of a judgment entered pursuant to a stipulation on the grounds of duress, that the wife signed it under duress.
Signed like a premarital, signed the dissolution agreement under duress?
And afterward was able to make a successful motion to set it aside because she was under duress. I guess I can't reward you, but
Let's see what I
it'd be worth $4 or $5 million to my client. And I don't know, I guess I could pay you as a legal assistant.
I'll see what I can find for you.
Stipulation
To set aside.
recited in court, step by step, approved by wife, became a judgment. She said, I didn't understand it. I was under duress. Judge said I was going to do worse if I didn't sign it. When I read it, it was during the time that his attorney was reading it into the record. I was reading the agreement. It was the first time I saw it, under tremendous pressure. Boy, would I love to win that case. I'm worried about getting sanctioned for filing it. I think I learned something at the bottom of 498. Both spouses' separate property is responsible for debts incurred during the community for necessities. So during the marriage, husband gets hurt in an automobile accident, incurs $78,000 worth of uninsured medical expenses, and the only money, his wife's separate property, to stay with that theme for a minute, they can go get her separate property. You know they can get the community property. It was a community property obligation, a debt incurred during marriage. But they can go get her separate property because it was for a necessity. If he took his girlfriend to France and didn't pay the credit card, they can collect on it from the community and from husband's separate property, but not from wife's separate property, in my opinion. That's because it's the doctrine of necessaries of life.
Okay, so in that case, can it be like the previous case you mentioned where if they get divorced, the debtors can't go after her separate property?
It's different because the debt arose during marriage.
Right.
In the case that I brilliantly lost, the debt was his before the marriage. It was a spousal support arrearage claim on the part of his ex-wife, and it was big. And the new wife, I think, had more money than he did or they did.
Okay.
This is interesting. Section D, like in Barry on 499, I don't think I knew this at all. After a date of separation, the duty of mutual support continues unless the spouses agree otherwise. So if the guy comes in for a divorce, should you just tell him to keep paying, even without a court order? I frankly often do, because she's going to get it from the judge, and he's going to be making peace by making sure she isn't getting evicted, by making sure she's at least solvent. I will tell you this, I got this $12,500 a month spousal award against my client last year. Now we got his 2018 financials, and his income went down a shitload. And we filed a request for order with the new ex-spouse calculation. Have you seen ex-spouses?
Yeah, we've seen it one, like just the website.
We sent a new ex-spouse, well, we attached a new ex-spouse calculation to our motion. set for hearing. Other side calls, we'll stipulate.
Oh, they got it.
Done.
Okay.
And it went down to $6,000 a month instead of $12,000.
Well, maybe it would have gone to zero if,
No,
you don't think so?
I assure you my client asked that question, but it couldn't have been less than the ex-spouse amount, in my opinion. And what we submitted was the actual numbers.
So does, opposing party, do they have a present spouse?
Say it again, please.
Does the opposing party have a present spouse? Like that
In
could?
that case that I just mentioned,
Yes. Oh, okay, okay. Okay.
and it's got a very interesting date of separation issue. They say 2015, we say 2010. 2010, he went and lived in his office, and he's lived in his office ever since. No sex, no going out together, no living in the same home.
How have they held themselves out then? What's their argument for
They never
having?
went out together.
Yeah.
They really didn't do much to hold themselves out as divorcing.
Okay.
They just physically separated. And it's really important because if we're right, all of his income, much of which is in savings, after 2010 is his separate property. If she's right, only his savings after 2015 are his separate property. Difference is about $250,000. He made $40 a month. His expenses were $2, and hers are $3. Period. So you got $35 a month left over. Yes. How about that? Can you imagine?
Pretty nice, actually.
He works about 100 hours a week.
Oh, wow.
He's a veterinarian, and he lives at the hospital to take care of the animals all night. If an emergency comes in, he's there.
That's cool.
The California system permits creditors to reach the non-debtor spouse's separate property without a judgment. I hate it.
Well, so 2122, right? Family Code Section 2122 talks about the grounds and times and time limits for motions to set aside a judgment. And C, one of the reasons is duress. I will now find the case, hopefully. Hopefully. Does that make sense? Did you look at that or? Okay.
But what was the duress?
The duress was
Pressure from her lawyer, pressure from his lawyers, statement by the judge that if she doesn't take the agreement, she'll do worse.
So I feel like you can do that on a judicial misconduct theory in and of itself. Was that said in open court or no?
Not the transcript.
Yeah, I mean, that seems like an ex parte conversation. And
I mean, everybody was in the courtroom. Everybody was
everybody's in the court.
open court with everybody present.
Oh, I thought you said nobody was present except for Commissioner Reed and her. Okay.
Oh, no, everybody
Everybody's there.
It was in the middle of the trial. Except she hadn't started her case in chief, and the judge made evaluations.
Yeah, that seems like a. Alright, let's do it.
Yeah, I'm having to use Lexis because I'm not really used to it.
Now look at section I, like an igloo. Bottom two paragraphs, the premarital support claim is enforceable against the community property of the obligor spouse, and it is enforceable against the separate property income of the obligor spouse. It is not generally enforceable against the earnings of the non-obligor spouse by decisional law. Of course, this limitation presumes that the non-obligor's earnings have been properly segregated. God damn it, ours were. Never put into joint accounts, all in her name. I think we got an incorrect ruling.
What do you try to recover from a judge after judicial misconduct? Because I think we learned that they can't be sued within that the other class.
Right, you're not gonna get
Judicial immunity.
Yeah.
Yeah. So,
We're not thinking at all about an action against her.
okay.
But I think her statement was inappropriate, clearly premature, and it added to her duress.
Also, you're trying to set aside the judgment. Okay.
When you go on beyond 9:15, it's all kind of gobbledygook to me.
Of the code section.
Yeah. I'll tell you what comes up not infrequently, and it often ends up in court, is if you've got a married couple operating a business together, and they're gonna get a divorce, and they can't continue to operate the business together. Sometimes they can. I've seen that. In general, they can't. And the court has to pick which spouse is going to be better qualified to operate the business. It's also come up in regard to who's going to get custody of a dog. They let the dog come in the back of the courtroom and see who he goes to.
Did they really? That's funny.
That happened once.
So it just keeps adding. It's not just spousal support, it's also child support.
Say it again?
It's also child support. It's like,
What's also child
so you can
support?
collect from the spouses. 50505.
What time have you been getting out? I don't need to think about leaving now, but what time have you been getting out?
Whenever we're done.
Yeah, this bus usually ends early.
Usually 7:30, 8 o'clock.
Yeah,
At the break.
Yeah.
a lot of times.
Nobody's gotten a brief about that?
No.
I was absolutely cold on the carpet on that. And we were the last ones here.
Last year was much different. Because we had Commissioner Reed and we would stay until 9. Sometimes 9:30.
Was she a taskmaster? Was that ethics?
Yeah.
Yeah, the thing that sucked the most, we weren't allowed to have our computers out because she thought that they were a distraction, and it meant that we couldn't take notes. I mean, not efficiently, you know what I mean? Because a lot of times, like, when you're writing hand notes and then you have to go back and transfer your hand notes to your computer notes, there's, you know, we're playing telephone. Yeah, you're playing telephone with yourself. But yeah, we would like sit at the end of class and like write like practice essays if we had extra time. It was miserable.
To stay until 9.
Just to stay until 9.
We'd have extra cases. She would bring in articles we had to read.
Yeah.
I actually really like Professor Reed, Commissioner Reed. But yeah, she's a taskmaster.
Yeah, the rest of the notes were all about restraining orders for the most part.
I don't know that I see much to really want to talk about. The comments under section 2045 toward the bottom of page 512, that's the language that's on the back of a summons.
On which page?
Page 512,
The ex parte.
referencing Family Code section 2045. The language under sub A, that is the language on the reverse side of a family law summons. That's one of the ATROs. The others saying you can't take any children out of the state. And another one saying that you can't change any will or trust. I think there's a fourth one that I can't remember right now. I'll tell you what I had as a problem if anybody wants to get in touch with me on this. You know, I always thought, and I think it's true, I always thought our professors, who later wrote books and sold them for a lot of money, got a lot of their information by asking their students to investigate such and such. And then the students would come up with good stuff and it would go into their book. So what was I going to ask you about? Oh, okay. I've got a number of divorces right now, not personal, that involve couples living together. The husband is a complete pain in the ass, verbally harasses, just makes life miserable. He's never struck her. He's never threatened her. He's never done anything horrible that would justify a kick-out order. But the environment and the situation just sucks. Does she have to live with him staying in that house until a divorce, which could take a year or more, is pending?
In order to get
To
what?
get him out. We want him out of the house. But there's been no grievous misconduct.
He's just like a negative person.
No, I mean, she can leave. Why does she want,
They want him
why is
to
it his
leave.
job to go?
Well, I had that precise statement made to me by a court.
Yes.
Yes, damn it, go.
Because I'm pretty sure we were in a case where you don't need to be in the house in order to like claim an ownership to the house. You can be the one to leave
Yes,
and
and
still stay a task mom.
You still have your rights.
Still have
That's
all
right.
your rights. So
So what I ought to say to these women who are suffering,
Go.
is just leave. But the one woman I'm thinking about has been in this house for 10 years,
right.
and she has a son who has a disease that its name I can't remember. He's substantially physically impaired. He's in diapers at age 9. Most of the house is outfitted with significant safety features for his safety, way beyond what you would have for a normal little baby. I mean, that house is like made for that kid right now.
So who's the caretaker?
The mother.
There's your argument.
That doesn't mean he has to go, and he won't. I mean, he's made her life miserable. He comes home at 12 or 2 o'clock at night. They live in separate bedrooms. He's just made her life miserable, but he hasn't harmed her.
But
Can't
how,
you just use it in the best interest of the child argument and say his conduct is a disruption to the child, and because the child has to stay in the house and she's the
That's an
caretaker?
argument for custody. If it's in the best interest of, that best interest issue comes up with who should have custody of this child. I've never heard a best interest argument used to have somebody thrown out of their home.
right.
It's court of equity.
Well, but, yeah, but and it's not
It's court of equity, I mean.
and without any kind of like, well, why are they miserable? Like, I mean, because he's showing up at midnight. Like, maybe he doesn't want to hang out with her between 5 and midnight.
You want a divorce, you go get it. Now you've served me with a divorce, which we have. I'm not filing a response, I'm not participating in anything. I'll leave when this case is over.
And it's a community.
Well, I don't have an income and expense declaration from him. I don't know how much money he makes. We think we have a good idea. Can't go to court and say this is the amount of support we want because this is his income. He hasn't filed anything, and I don't know that he's going to file anything.
What happens when a spouse just refuses to play?
Refuses.
To play.
You go into court.
Participate, I should
You
say.
go into court. No, that's perfectly fine. You go into court and you have a default prove-up hearing, but you better have made it clear in your pleadings as to exactly what all the properties are. And if you're going to ask for child and spousal support, you better have evidence of his income. And if he hasn't participated, you really don't know. She finally got a pay stub. And he makes about $12,000 or $13,000 a month, and we're entitled to half of it. What's the disease that a kid? He can be very bright. And he can't. What?
Asperger's?
He's extremely autistic.
Extremely autistic. Was so autistic that he's in diapers.
Yes.
He's nonverbal.
Normally, is he verbal?
I don't know the answer to that. But he'll never be able to live on his own. Child support will last a lifetime. He's severely autistic. Lady's as sweet as she can be. I told her, start dating if you want. So then last week I wrote to her and I said, why don't you just bring him home for the weekend? He'll leave. Your husband will leave. And I said, don't do that. That'll create a problem. I said, you might bring him home for a candlelit dinner in your dining room.
I would so not be into being somebody's like, you know, leverage. You know what I mean? Like I would be like, come on, can we just go out? Like, I don't know. It'd be hard to find somebody that's willing to be somebody's leverage. I'd have to really, really like a girl first before I'm willing to let them use me as
I think he
leverage.
does.
Yeah.
Anyway, what do I have to prove to get a residence exclusion order?
It's a community house.
Yes. Did I tell you about the ex parte we did file because of the 15-year-old girl entertaining multiple guys all night? The family grows marijuana in a storage locker. They bring it home and trim it and put it into boxes. She sells it at school. She's about a sophomore. She sells it at school for $35 for a small amount and has to give her father $15. All night, young guys come and sleep with her. We know that because she's told her sister that, and her sister has told her father that her sister has told her that. And we asked for an order giving custody to the father.
To the father. Okay.
Mother just lets her run wild.
Oh.
The judge denied the restraining order, has a statutory obligation to explain why, said nothing, set it for a hearing 2.5 months out. So she's now being exposed to pregnancy, diseases. Potentially her guys are going to get caught up in rape charges. Not all of them are high school guys, some of them are older. She's going to get arrested for possession or sale of drugs.
So that's the father's fault, you said, right? You said I thought you said she has to pay her father $15.
I'm sorry, her stepfather.
Oh, okay,
Her
okay.
stepfather, her mother's husband.
Oh.
They're all in the business of growing and selling marijuana.
Okay.
The father is beside himself. He wants that girl in his house where he can discipline her life. That restraining order was denied without comment from the court. And if you look at If you look at the Domestic Violence Prevention Act, it says if you're going to deny an emergency request for a restraining order, you have to explain why. Nobody does. If they write anything, they write insufficient facts. But most of the time, they don't write anything. And you certainly set it for a hearing sooner than 2.5 months out. This is not an easy way to make a living, folks.
Right. Right. Because if you lose your argument, a child might be hurt. I mean, that's sad. You know, like.
Well, in the high desert, they denied a restraining order and the wife was murdered. Sometimes, in the presence of a restraining order, the wife is murdered.
Well, that's not, I guess at some point you have to realize it's not, you know, you're not having sex with the guy in your room at night. You know, like you know, you're not the girl. You know, so, you know what I mean?
Yes. And look, here's the language of 6320, which deals with an ex parte restraining order. And is disturbing the peace of the other party sufficient to get an exclusion order? They've added animals to the restraining order statute because one of the threats that comes about not infrequently is I'm going to cut off the head of our dog and leave it with you. So they've got a pet protection provision in the domestic violence pleadings now. I love this. Fucking legislature's just nuts. They can order you to not encumber the dog. Which is what? Place them as collateral for a loan. What do you call the guys who loan you money for a short period of time?
Loan shark, yeah.
Not a loan shark. It's a guy who has billboards all around.
A pawn.
Yeah.
Okay, you could pawn your dog and you get him back and you pay back $100. So you can encumber the dog.
It's dogs with $1,000, man.
You cannot.
It's got papers.
You cannot take, transfer, encumber, conceal, molest, attack, strike, threaten, harm, or otherwise dispose of the animal. I can just see an OSC rate contempt. Sorry, Your Honor, but our client reports that her husband has had sexual relations with our puppy. That's a violation of the no molestation provision of the restraining order.
Only family law.
I do have a dirty joke. Can I proceed with that?
Yeah. Should we turn
I have some great friends who really devote their lives. The husband's very, very busy as a stockbroker. The wife is really pretty much a world-renowned parachute jumper. And she's one of these people that gets in 135 people with different formations as they have their 30 seconds before they have to pull their chutes open. And there was a story about these, I think it was guys in the Army who were learning to be parachuters. And this one guy wouldn't jump out of the plane, he was scared. So the sergeant was screaming at him. He said, if you don't jump like all the other guys, I'm going to do you in your ass. And the other guy said, did he jump? And the answer was, a little. So all of these on tape?
Yep.
Okay. So be it. This was interesting, with regard to, they're just so unrealistic in the real world. And I may have told you this story before. If I did, I apologize. But there was a woman who hired a man to kill her husband. And it didn't happen. But she was charged with conspiracy to commit murder and convicted and imprisoned. After a while, she filed for divorce and a request for order for spousal support. She had no income, although she didn't have much in the way of expenses. The court ran an ex-spouse, I think, and concluded that she was entitled to X number of dollars for spousal support.
In jail?
In prison.
Oh.
And that was affirmed on appeal because there was no statute or case that said you can't get spousal support if you've hired someone to kill your spouse. So they added that to the statute. And it now says that attempted murder or soliciting the murder of a spouse, you're prohibited from awarding alimony.
Nice.
I know you lose the option of getting their pension, but I wasn't sure about alimony.
I've
I
already
didn't know about the
finished.
pension. You lose your ability to get their pension?
Yeah.
I guess I've had one case of attempted murder by the wife against the husband. She was tried and convicted and went to prison for many years and may still be in prison. And I had another one in which I saw a guy who was just really crazed and gave me $10,000 and said to process a divorce quickly. I mean, I didn't hear from him, except in the news the next day, they found his wife's body in a La Quinta country club home. He had fled the country, he went to England, and they didn't extradite, and he died before he was punished in any way. Heart attack.
How long ago, regarding the duress case that you have, how long ago was judgment entered?
About 8 or 9 months ago.
Oh, okay. Good. I was here within 2 years, just chicken stuff off.
I think we're dealing with a 1-year statute.
You think so?
I saw a multiple of statutes dealing with setting aside a judgment, statutes being different based on the basis of the motion. Fraud is 3, I think mine is 1, and we're monitoring that. And I have told her that I think her better case is against her divorce lawyer. He should have walked out and he said, Your Honor, I'm not agreeing to anything today. I'll be back tomorrow morning. Let's look at the Chapter 7 summary, please, on 524. What does it mean that spouses have equal management and control rights to the community personal property?
They can do they both have access to it and they both have the ability to use it, obviously within certain limitations and under the duties of good faith and stuff like that, but
what does it mean to manage community property at all?
like take community funds and invest them, or take community funds and buy something for the community, or
If you buy something, is that management of community money? I guess so.
because you're managing cash into property, I guess.
We'll also say, it says equal, it doesn't say
Exclusive.
they each have exclusive, they each have equal. So I guess they both also
And that follows historically from the fact that men had exclusive control of everything until society became enlightened. I do like the bullet point under the third bullet point that says under family code statutes, a spouse does not have the right to destroy community property without the other spouse's consent. So, if you want to burn your vacation home because you can't afford it anymore, you can't do that without getting permission from your wife.
And making her a co-conspirator.
Making her a co-conspirator. Now, look at the top of 525. Equal management and control means that either spouse acting alone has an absolute legal right of disposition. But haven't we talked about you don't have that right unless you've made disclosure and have your wife participate in the decision?
I think that either spouse can bind the rights of the community with regards to a third party, but then the spouses have rights of reimbursement upon each other.
Probably only if it involved the acquisition of something that wasn't for the benefit of the community. If it was for his own benefit.
Well, either way, right?
Oh, you're right, because if it's for the benefit of the community,
She has no complaint.
There's no complaint, yeah, there's no damages.
And then here's bullet point number 2 at 525. Confirms the accuracy of my earlier comment that that legal right does not extend to testamentary matters. If you've got a will or a trust, all you can do is control your 1/2 interest in the community property. You can't deprive your spouse of her share of the community property. So if the whole thing that you own is a $100,000 bank account, you can have a will that says, I hereby bequeath $50,000 to my girlfriend in Madrid. That's kind of okay. But not her $50,000, not the wife's. The conduct of spouses in a marriage is often just wrong. People do things to their benefit or the disadvantage of their spouse. And if it gets before a judge, it's just not going to be permitted. It's going to be set aside. Have you studied 2640?
Maybe. Which one's 26?
Yes, is the answer. That's the assignment.
It's a reimbursement for a separate property contribution.
Yes. There you go. Reimbursement.
So, if they buy a $400,000 house, they pay 25% down, $100,000, comes from husband who had inherited it from his parents. Then the mortgage is paid down with community property earnings, and the value of the house goes up to $500,000. And the debt at the time of separation is $150,000. So there's now equity of $350,000. Who gets what?
They get their pro tanto share. Was it a community household, or was it bought before the marriage?
Purchased during marriage,
Oh,
down payment, separate property of husband.
yeah, then.
No, you only get your reimbursement.
Yeah, you get your reimbursement of the down payment, and then any reimbursement if you use your separate property to pay any of the principal.
No, yeah, but you don't get your interest.
Isn't in this.
So no interest, no principal is paid with separate property?
Correct.
Just the down payment separate property?
Correct.
Then they get their separate property contribution back.
And I believe that's it. You don't get
And
like
then
a constructed trust idea where you get your share of what that, like, you know what I'm saying? I think you only get your reimbursement out. You don't get any kind of equity, like.
The house is sold, $500,000, forget about the expenses of sale. The debt against the house is $150,000. What do you do with the $350,000?
So he gets his separate property contribution back, and then they split the remaining 50-50 as its community. Correct?
Do you agree with that?
No,
I'm pretty sure that's the answer. That
It is.
yeah.
That's the answer.
no one gets back.
Now, I've got two cases right now
You would want to get more.
in which
That's not the way it works.
some very skillful lawyers are just pounding on the fact that payments on the mortgage were made with the husband's social security.
So
That's completely his separate property by federal law. And they've given me 10 years of bank statements showing his payment on the mortgage with his social security money.
But bank statements don't count for tracing principles.
Wait,
I
really?
thought you have to have like records made at the time, and that regular bank records don't count.
They do. They're made at the time the transaction takes place. What is your authority for that statement, Counselor?
The book.
The book?
I have to figure out where it is, but yeah, because
No, I think that's exactly how you prove it, is with the bank statements. Shows automatic deposits of social security, automatic payments to the lender.
He's due a reimbursement of all of that, but he does not get the property because of that. Now, it may be evidence that it was always separate property, that if that's where he's going.
No, he just wants all of his reimbursable separate property reimbursed. In that case that I've described, the $100,000, and also if there's been a reduction of principal, as you said.
I don't think he gets the principal.
or we guess the principal if it's a separate property.
Because to the extent that he's
Sure.
paid down on the principal debt with his separate property,
Yes.
that's reimbursable under
Yes.
2640. Now, how much interest does he get on the $100,000?
None.
I don't think you get anything. No,
You
you
know you
just
lose your interest.
No interest. My first day of law school, we had a lecture by a Supreme Court justice in Kansas. He had just finished grading summer bar exams. This was mid-August of 1973. And he said that one of the blue books that he got, you know what blue books are, not computers?
Yeah.
One of the blue books that he read in grading bar exam stuff said, I do not know the answer to this question, but here is where you would look it up. And he gave some specific information as to where you would look it up. He said, I consider that an accurate answer.
There we
He's
go.
not an 85-year-old Supreme Court justice.
Like in that case, I just do it. It's on my notes, I swear. Like, for any bar question.
So I suggest to you, sir, that if His Honor or Her Honor says to you, what is your authority for that argument, Counselor? Your answer had better be more specific than the book.
Well, I'm trying to find it in the book.
That's fine.
I think it's.
Yeah, I think it's one of those cases where they just didn't have enough bank statements, or it was commingled. You couldn't tell which dollar came out of.
can't be that every case regarding the duress has failed. That can't.
Is that what you're telling me?
Well, no, I'm telling you that I'm finding cases where the duress argument has failed. And I'm
Have you found one where?
not yet.
Yes.
Not yet.
That's my problem.
I have.
Not yet. You have?
Yeah.
Well, then,
Well, it seems like it. In Ray Marriage of Gonzalez. Or not Gonzalez. Yeah, Gonzalez.
Stand by, please.
Seems like it works. It's 57 Calap 3rd, 736.
57.
Calab third, what?
736. Because it says there's no legal standard of resistance with which the person acted upon must comply at the peril of being remediless for a wrong done to him and no
57 Calap 3rd.
736. It says duress, which includes whatever destroys one's free agency and constrains him to do what is against his will, may be exercised by threats, importunity, or any species of mental coercion.
Maybe that's Gonzalez.
Yeah, Henry Gonzalez. And then they cite like a bunch of cases that deal with duress.
Was the decision in that case to set aside the judgment?
Yeah, because she supposedly gave up property rights for custody. And that's what it looks, just from the quick skimming.
What was the conduct that constituted duress?
Where is it?
You're just finding a plethora of cases in which the request to set aside a judgment was denied and affirmed on appeal.
Right, what being looked at now is an older case, and it's citing a different code section.
Well, but only a civil code section.
Here, the husband said,
It's what it says.
time's getting short now, and I'm tired of arguing over it. Something's going to be done today, and I mean now. Later during the same argument, which lasted from 3 until 5, Dan declared, we've only got an hour and a half left, and it's getting close to that notary to close. You're going to have to sign today because Monday morning you won't have anything. You better make up your mind whether you're going to lose it or whether you're going to sign this paper or lose your property. This is the word and conduct above set forth clearly come within the framework of the authority heretofore cited.
God,
So basically he's saying, you sign it now or you lose everything. And that's basically what Commissioner Reed said, is you either sign it now or you don't get.
Well, of course, that's harsher, really.
Yeah, because it's coming from a judge rather than a husband, and the judge is the one that's going to decide
No,
it.
but the judge didn't say anything close to sign it now or you're going to lose everything.
Well, not everything,
Her Honor said, from my understanding of this agreement, what you're getting is a good deal and better than what you're headed toward getting from me.
I mean, to me, that I feel like it would have more force coming from the judge than it would coming from your angry husband, because the judge is the one.
That's true.
The judge is the one to decide what you're gonna get. Whereas here, she can like go screw yourself. We'll let a judge decide. Okay, so. It says that It's the Hicks mix method in order to have C compliant records. So you have to have says Hicks mix requires 4 doctrinal categories of proof. One is C compliant records, which is just independent records made at the time of the transactions. 2 is proof in the form of a written declaration extrinsic from the bank records. 3 is proof that the separate property owner intended to use the separate property sums on deposit to make the purchase and did in fact so. And 4 is disclosure to the other spouse. But that's to get it back. But it says C compliant records are required, and then in C, standard bank record. Yeah, so on page 349, the heading for section C says standard bank records insufficient for rebuttal.
That's not exactly what you said.
And then it says standard bank records are generally not sufficient evidence with which to rebut the community property presumption as sums on deposit or purchases made from commingled assets.
I'm saying that bank records are sufficient to trace separate property payments on real property, giving rise to a 2640 reimbursement.
Right. You see they're just siphoning it off. It's a different issue.
Now, I'll tell you a story. We just conceded because they sent us the documents. I had 2 different people go through them. And we think that their 2640 reimbursement claims are valid to the penny. And they asked us to admit that. And we did.
Oh, wow.
And that eliminates their obligation to prove it. We just admitted it. But we had to admit it because they supplied it to us and the numbers were correct. So we've conceded an $85,000 reimbursement to the husband.
Now, can you concede as to the money that you have presented? Like, I'm sorry, go ahead. Sorry. It seems like it's dangerous to just admit it.
It is. It's disaster. You've lost any argument to the contrary. But if somebody sends you a written discovery demand that says, please admit the following, and then to summarize it, all payments made on the community property house on its mortgage have been made from the separate property Social Security income of husband, and all the documents prove that, you have an absolute obligation to admit it. Now, trial pending, got a case, guy's had a lawyer looking over his shoulder the whole way, but he's not had a lawyer in court in a long time. He's going to try the case himself. He's been taking care of a community property house out of state and has spent a lot of money on it and has given us an itemization of the reimbursements to which he claims he's entitled. He's never sent a request for admissions. He's never sent an interrogatory about it. He's never done anything about it. So when we get to trial and he testifies, I'm entitled to $50,000 in reimbursements. And my question is, prove it. He's going to say, here's my box of canceled checks and bills that I've paid. And I'm going to say, hearsay, not authenticated. They're not going to come in. I think we can defeat it. He doesn't know how to get them into evidence.
He doesn't know how to get to them now.
These lawyers did
Yeah.
properly.
It is hearsay, but it's not.
No, but it's hearsay.
But it's an exception. There's going to be an exception to
A
that.
business record? No. If it's coming in as a business record, you have to have the custodian of business records come in and say, I'm the custodian of these records.
Why do you think so?
These were created in the ordinary course of business. These were created at or about the time that the debt was documented. And these are true and correct copies of the originals that were created. And that's how you authenticate business records and get business records into evidence, even though they are otherwise hearsay. He doesn't have, this is 15 different providers. He's not going to have any of them in the courtroom from Oregon, where the house is and where the bills are paid. I don't think he's going to get him into evidence. Do you? Do you think he can get into evidence? I've paid $50,000 worth of bills on this house over the last 5 years. It was for gas, electricity, taxes, mortgage. Is that credible, determinative evidence because he says it?
No.
Are those documents going to come into evidence?
I would say no, because unless they are subpoenaed bank records with the declaration from the custodian of record.
That's it. That's the critical element.
I just don't know if, does the family code follow the hearsay rule, or
Or is
because
that-
court of equity, is they just like,
Is that an important point? People have said that the family law bench is unacquainted with the California Evidence Code.
I've heard that before.
I made many friends and many enemies when I took the family law bench and said, wait a minute, that's not admissible. What? We've gotten these into evidence for the last 25 years. Well, your offer of admitting that into evidence is denied. And people cheered because I was enforcing the rules, and others were beside themselves because they had never prepared a case correctly. And we're required to.
Yeah, you think that they'd, make you follow the evidence code in court. Who'd have thunk it?
We have a new commissioner in the family law bench who lets litigants talk about any issue or any argument they want. The fact that it's never been put forth in a pleading doesn't matter to her. I want to hear what they have to say. But Your Honor, they're making an argument that we've never heard before. It's not in any of their pleadings. We've had no opportunity to respond to it, to even discuss it. I want to hear what they have to say. That's a crop. You can argue what you have put into your pleadings and put the other side on notice about it.
Yeah.
It's called due process and an opportunity to be heard. And it is not due process if you're called upon to respond to, for example, accusations that have never been made before. That's why, as the moving party, you file your papers. As the opposing party, you file your opposition in response to his papers, and why he gets the last word, responding to your opposition. Everybody's now had an opportunity to respond to what the other side has said. That's due process.
Well, but it seems like if you were in trial and somebody's making an argument, you would have at that point an opportunity to respond. I mean,
This is not trial by ambush.
okay, but
I mean, if you're bringing up arguments in the middle of trial that's never been brought up before, how do you have no proof other than your word.
Yeah.
Yeah, but what if they have some kind of a document, whether it's true or not?
Then they win.
Why? You
No.
had no way to even know about it to rebut it.
Well, no, because you have your disclosure requirements. Did they?
But they didn't, and the judge is just saying that they want to know.
No, he said it was an argument brought up at trial. I'm saying you can bring up an argument, but as your evidence needs to be disclosed within the.
He's saying accusations.
Just accusations?
How about,
They're not bringing in new evidence, right?
how about the father brings up that the mother has completely neglected the child. Whenever the child comes over to visit, he's filthy dirty, in ripped up clothes, hasn't eaten, hasn't bathed, he's a mess. And the mother says, and that's in his pleadings, in support of his custody request. Mother, in the case I'm talking about, hasn't filed anything. One rule would say, you won't be heard
Oh, I think they should.
I don't know.
because you haven't filed anything. You haven't responded to them. You haven't put them on notice as to what your arguments are. Judge says, I want to hear what she has to say. And she says, well, that's just false. The kids are always clean. I take meticulous care of them. They go to the dentist every 6 months. Their clothes are good. They are good. It's just not a problem. Your Honor, I object. I move to strike that. It is not consistent with any pleadings because there are no pleadings. Objections denied. Overruled. And by the way, Your Honor, the mother says, about 4 years ago, he molested our daughter. I acted improperly. I stood up and I threw my pen on the table. And I got in trouble with the judge, and I shouldn't. I said, that's just ridiculous. She's never said anything like this before. And at that point, this was actually the third time she was talking about something that she had never pled anything. So anything she said was outside of the pleadings. And this was the third time. And on the third occasion, after letting the first two come in, she said, now listen, you've never made that accusation before. They had no idea what it would be and no opportunity to respond to it. So I don't want to hear about it. Okay. But the first two arguments came in. And of course, she heard the accusation that my guy had molested, at that point, his 3-year-old child. Great. You talk about unringing a bell, that can't be done.
Right.
Well, Commissioner Reed talked about that. She said her law, I'm assuming it's Commissioner Reed, but she said she likes to let the parties just vent so that they get it out of their system so that they're better off after they leave because they just want to be heard. And
We're
supposedly,
not social workers,
no,
we're
but
judges.
that's how she's treating it. Like she wants the people to be better off after they leave.
They may feel better.
Yeah,
You could also make them feel better by just ruling in their favor.
yeah, it's
You
not
make them
supposed
feel
to
great.
be bias, but that's just
No, I think that's wrong.
well, that's just the explanation she gave us for why she does it.
I understand, she's not a social worker, and she's not a psychologist. Your job is not to facilitate people feeling better when they leave the courtroom. I had a day early on in my bench time in which I made a ruling that both sides were very unhappy about and made it clear. When we took our break, went back into chambers with my deputy, I said, somewhat on the slide, or not sincerely, but I said, I certainly didn't make anybody happy out there today. And he turned to me and he said, that's not your job. And I said, you, sir, are right. So I don't want to do anything to go out of my way to make somebody uncomfortable. I want to avoid that like the plague. But I think it's quite inappropriate to let people vent or talk about things that aren't in their pleadings so that they feel like they've had a better opportunity to be heard by the court.
But what's the rule that says that you have to say everything in your pleadings or you can't bring it up at trial? I mean, you have to.
It's irrelevant. The issues are framed by what you have written and served on the other side.
What's the code? Is that procedures or is that evidence or what do you?
You have to give me some time to
just
find out. But I mean, I don't have a citation for you.
Right.
I'm at fault now. But I assure you that
I just don't think I've heard that before. You have to give all your evidence up. You have to give all your witnesses up. You have to make your full disclosures. The mandatory ones. The automatic ones and the ones that appear as you go on. But I don't remember a rule that says that I need to tell you my argument.
I don't know that you have to tell anybody your argument. You just can't argue about issues that aren't in the pleadings.
So it's just fast on evidence. You need to bring in some kind of evidence to. So you say like it's a fact, not an evidence. I mean,
no,
because they're bringing in evidence right then.
No, my argument would be that issue is not before the court.
Okay. Huh. That issue is not before the court, so it's okay.
You hear that every day in the courtroom. You guys had any opportunity to go sit to a morning calendar?
Yeah, not family law.
It would be good if you did, and I understand you might not be able to, but especially pro pers, which are about 80% of the litigants in the courtroom, bring up stuff all the time. And in that situation, the other side doesn't even object, because they don't know that they can object. You have to put the other side on notice as to what you're going to be arguing. You can't argue outside of the record, and you can't argue issues that aren't before the court. I mean, people frequently go in on custody hearings. And when the court makes a decision on custody, they say, well, what about my car? She's got my car. It's not before the court. File a request for order. I want attorney's fees. Did you check the box for attorney's fees? And that's all you really have to do in most of the pleadings in family law is check a box. So if you don't check the box and you want to argue something with regard to that issue, if I were on the other side of the case, I would object, and if I were the bench officer, I would say that's not before the court.
It's like in a civil trial, I'm trying to bring up an affirmative defense during trial.
Very
and
important.
Saying, well, no, they're contributory negligent. You never even raised that one.
Right. So you say that's been like waived because you didn't bring it up as affirmative defense, but
that's why you always have an affirmative defense that says defendant reserves the right to add additional affirmative defenses at the time of trial.
Right.
Whether or not that's permitted, I can't tell you. I probably would. They've said they want to be able to go beyond that list. Sure, I noticed that they might very well do that. So I went to speak to my law school when I was on the bench and went back to Topeka. Not many people came. I was embarrassed. But everybody in those rooms that I used to study in with pens and paper, everybody had computers in front of them. They didn't even have to bring them to class. They were just there as part of the classroom now. I guess they forwarded it to themselves when they left. How come you don't have one? You're supposed to have one. You've got paper and pen. I think that's sufficient. So you're on the bench and somebody comes up with an issue that isn't in the pleadings. And it's an important issue. And it needs to be decided because there's a dispute out there that they're arguing about. And it's nowhere in the pleadings. You don't let them talk about it?
No, you say we're gonna stop them from talking about it first off, and then tell them that you need to be briefed on it with allowing the other side a chance to respond, and then set a hearing 30 days out or whatever, and then rule on it.
So you're in the middle of a trial, and you have testimony about all the assets and all the debts, and all of a sudden the respondent says, and by the way, I think they breached their fiduciary duty with regard to the handling of that bank account last year.
Yeah, that's,
If you're in the middle of trial, then.
no,
Although in family law, you can reopen it. Can't you reopen a dissolution proceeding for deceit and fraud and saying that?
Why didn't you plead that before?
Because I'm pro per and don't know the family code.
You shake your head just like they did. The law says you treat pro pers precisely as you treat lawyers.
Yeah, but
They are held to the same standards.
but they're
Do
not.
judges hold them to the same standards?
No.
Not close.
Not even close.
Can you lose cases when you represent a client and the other side is unrepresented?
Yes.
And the court feels like you're running all over them. You know the rules. They're helpless. I'll rule in their favor. The hell with that.
And then you appeal it. And that costs your
Oh,
client
appeal
money.
it. 1 to 2 years,
I know.
$10,000 to $20,000. File an appeal.
I know. Then you know that judge does it, and then you just continuously file whatever those motions are to say, I can't get a fair trial with you.
we only get one.
You can't exclude a judge after you've appeared in front of that person.
Well, no, I'm just saying, you know it based on that one trial, and now every other trial after that.
Well,
You disqualify that judge.
Yeah.
Great PR. Pisses off the other judges, adds to their workload. I had one CCP 170.6 in 10 years. Just one. I mean, I had a lot of people that didn't care for my rulings, but I only had one person file that before ever appearing in front of me. Actually, in substance, there were two. Because one day I got a motion to suppress on a criminal case once, and I granted it. The DA never would permit another case to be heard by me. I'm sorry. They were trying to suppress a bunch of guns that were taken from a home.
were they
The
lawfully
police-
taken?
Pardon me?
Were they lawfully taken?
Well, you tell me.
No.
The police knocked on the door, believing on credible inside information that the house had a lot of guns under the bed. And the police said, we think you have a lot of guns in this house, and we want them. Do you have a warrant? No. To get them? No. To come in the house? No. Well, we're not going to let you in. The police said, we think it's dangerous for your children to be in this house that we believe is got lots of guns in it. So
Sounds like California.
we're calling Child Protective Services now to come before we leave and take the children away from you to a foster home that doesn't have guns in it. And the people said, come in. And they did, and they found half a dozen weapons, and they took them, and they left, and they filed criminal charges for illegal possession of weapons, parole violations, God knows what.
Well, if they're on parole, then they don't even need a warrant.
I misspoke.
Oh.
So the defense made a motion to suppress those guns, unlawfully seized.
Sure.
I said, that just wasn't a voluntary acceptance of their request. I suppressed the guns, and that case had to be dismissed. and I never saw a district attorney again.
In ETAs? Oh, wow.
That was my one criminal case in my 10-year career.
Wow, so the whole DA's office just papered you?
Well, I'm sure they went back and said, "Yeah, Commissioner Mack just granted a motion to suppress." I think they're granted about 1 out of 50.
I won a couple when I was working in the public affairs office for a couple of years.
Good for you. Everybody has to obey the goddamn rules.
That's true. Unless you're proper.
These are stops though, they're just bad stops. I think they're both bad
The
stops.
traffic stops.
Yeah, well, that lead to, that run out of control. Like you didn't have,
Did I tell you about the charges lodged against a close girlfriend, not a girlfriend, but she was, I can't think of the word. She was driving without her foot on the gas or the brake. She was coasting. She was charged with coasting. Ever being charged with coasting?
How would a cop even know that?
How would he know that?
Unless they admit it.
it's fine, yeah, no, it's speeding light. Basically what the cop probably did is he probably pulled her for speeding, thought she was cute and gave her a ticket for coasting instead.
That is exactly what happened.
Yeah, that's probably what happened.
That's exactly what happened. But they pled not guilty. Her husband thinks he's a lawyer. He told me that he had appeared before me a number of times. I didn't know. And he always won. There's all kinds of ways to win a ticket. Coasting
Is speeding without your foot on the gas.
Coasting, is, the violation is only if you are coasting in neutral. If you are coasting in drive, that's not coasting.
That's driving.
Well, you say not driving either.
I said that's driving.
It's 8 o'clock, we never even took our break. I think this chapter had some important points. People are supposed to deal honestly and openly with each other. You don't hide assets. You don't give away assets.
Yeah, your essay's in there if you want to read it.
Oh, we're supposed to go back to Veronica though.
I'll go back. You did very well
Yeah, we all got A's, man.
In what?
on our midterms.
Did you?
Yes.
They've already had midterms and graded in their back.
Yes.
Yes, sir.
And you got A's, everybody?
I got a 97, Will got a 95, and
Victor
Victor
got
got a 90.
So the question
That's
is,
the highest grade semester.
That's the highest,
Oh.
yeah.
the question
I guess the
is,
highest ever.
there's a number of questions. Is Natalie a superb teacher? Could be. Are you guys superb students? Could be. Was the question or were the questions too easy? Could be. Were they graded too easily? Could be.
I think it was a mix between easy question, easy grading, and smart students and good teacher.
All of those.
All of the above.
All that's E, all of the above.
All of the
All
above.
of the above.
Everything played a factor.
Nice to see you guys.
As well.
I do enjoy this and would love to team teach with Natalie, but I gotta tell you this, most nights I'm in bed by 8:30.
Me too if I didn't have class.
Yeah, it's hard sometimes when the class goes all the way to 9 or even a little after 9. It's tough
And
night.
I have to drive all the way back to Palm Springs and try to fall asleep.
You live in Palm Springs? You live?
Pop visit.
Me too.
So there you go.
So you're 10 minutes away, 5 minutes away?
Yeah, 10 minutes.
I live in Palm Desert.
And then they shut down the wash because it's windy.
Oh, you're
And then it takes,
the whole
and
way.
then it takes another
It's an hour and a half to get home.
45 minutes to get home.
Are there closures now?
No, they're open now. At least I hope they are because there was a wall of sand as I was crossing the wash to come here.
Tonight?
Yeah. On Gene Autry.
Oh. I believe
And they
that.
closed Indian yesterday, even though I didn't notice any
bad
wind.
in Palm Desert at all. What's that?
Those are midterms. I gotta get Veronica. Do you want me to take
I want to turn the talk, make sure she knows about that.
do you want me to,
I'll follow you.
do you want me to take the, oh, you're gonna get rid of that as well?
Yeah. Good night, guys.
Right next to you.
I don't know.